In this video, we're going to discuss a common question I'm asked, which is, can I sue my employer for injuries suffered due to their negligence? In Pennsylvania, there's a workers' compensation statute which limits an employee's ability to sue their employer. Now, the upside of the workers' comp statute is that the employee doesn't have to prove fault, doesn't have to prove that the employer was negligent. They only have to prove that the injury happened during the course of their work. But the downside, and it's a major downside for employees in Pennsylvania, is that they're limited only to their lost earnings and medical bills, and they are not able to make a recovery for pain and suffering, loss of the enjoyment of the pleasures of life, and other non-economic damages. So the workers' comp statute severely limits the amount of financial damages that an employee can seek from a work site injury. Now, the analysis does not stop there. Anytime an employee is seriously injured on the job, they need to contact a lawyer and evaluate whether there were any other third parties. So were there any other subcontractors involved, or was there anybody else other than the employer that had a role in why the injury occurred? An example would be on a gas line project. So imagine that a big gas company and its employees are putting in pipeline. But separate from that, there was a third-party inspection company that was hired specifically to make sure that the lines were connected, attached, and set up appropriately and safely, but they didn't do their job. And then later, as a result of the failure to do their job by the third-party inspection company, a line blows and the gas company's employee is seriously injured. Well, in that situation, the employee would have a workers' comp claim against the employer, the gas company, but they would also have a regular negligence claim against the inspection company because the inspection company was not their employer, and it was just another entity that had a responsibility to do something to protect that employer and everybody else. And so the employee is able to sue for all legal damages available against the third party. Now, the final little catch there is that if there's a successful workers' comp claim, the comp insurance company and the employer may be entitled to get the money that they paid out for workers' comp from the settlement or verdict against the third-party testing company. The thought being, well, that company was more responsible than we were in causing this, and as a result, but for their negligence, we wouldn't have had to pay out this comp, and so you should have to pay us back. The good thing is that whenever there are those liens or subrogation interests, that situation where one party is looking to get paid back from the settlement against another party, it usually comes at a significant discount, meaning if you were granted, say, $100,000 in total workers' compensation damages, when you file your lawsuit and say you reach a settlement of $500,000 with the third-party testing company, the employer is only going to be able to recover around 60% or $60,000 versus $100,000 of that lien, which can mean additional savings and money for you, the injured person. So the question is, can I sue my employer for negligence and pain and suffering damages? The answer is generally no. However, you need to pay close attention to find out if there's some other entity that was involved, because against them, because there's no employee-employer relationship, you can get all the damages to make up for what happened. If you have any other questions, please check out our website. Thank you.